Okay.
Good evening. This, as you know, is Dale Steady Merced. Today is Tuesday, January 30th, 2018. This webinar is being recorded. I must review a few important items before we get started. This is going to sound familiar to you because we've been saying the same thing for the last 6 years. But I nonetheless have to remind you of some important items. First, an affirmation form was included in the email I sent you with the training outline. It's also, I just uploaded them to the handout section on your control panel. So if you can't find the email, that's one way to get it right away, which is right on your handout section of your control panel. You can download it to your computer directly. At various times throughout the webinar, there will be various codes displayed on the screen. These codes can be numbers, a combination of words, or both. You must write down the codes on the affirmation form. The codes will not be read out loud. I repeat, the codes will not be read out loud. Can you please advance to your second slide, Mark?
Will do.
The course code is now displayed on your screen. Please write the course code number on the affirmation form. Again, please take this course code and write it on your affirmation form. If you do not have an affirmation form in front of you, write it down and I will get you the affirmation form after the program, but write the course code down on a piece of paper. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by the New York State Education Department for continued certification as a hearing officer. Please keep in mind that only hearing officers who participate in the entire webinar session would meet the training requirement and are eligible for CLE units. CLE credit will not be awarded and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, February 9th, 2018. Again, the affirmation form has to be received by me by no later than Friday, February 9th, 2018. The affirmation forms give you 3 options of how to get that affirmation form to me. You can mail it to me, you can fax it to me, or you can email it to me. Affirmation forms received after this date will not be considered for CLE credit, and New York State Education Department will be informed that you have not met the training requirement. I do want to point something out. I do have a new address where to mail the affirmation forms. So please make sure you review the affirmation form for the correct address so that it is mailed. If you're going to send it by United States Postal Service, it is mailed to the correct address. Otherwise, fax is okay, or an email of it is fine as well. Second, all participants are muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to receive as many comments as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there's a question dialog box with the wording "Type questions here." We will pause to take questions or comments throughout the 2 hours as time permits. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Please take a minute or so after the program to fill in the feedback form. You will also be reminded, I believe tomorrow GoToWebinar automatically sends you a follow-up email that will also allow you to complete the feedback form. But preferably the easiest thing so you don't forget is as soon as the program is over, a new window will pop up with the feedback form. Just fill it out, click a couple of things on it, and it will come through to me, directly to me through GoToWebinar. With that, let's begin. I'm turning it over to Mark Weber. Thanks, Mark.
Well, thank you, Dale Steady, and thanks everybody for participating. I do want to echo what Dale Steady said a moment ago, that the purpose here really is to try to meet your needs as much as we can. So to the extent that you've got any questions or comments, we really would appreciate you transmitting them in the way that the that GoToWebinar permits you to do. So with that in mind, what I want to say about what it is we're talking about is we had the idea of doing a program generally on prospective relief that hearing officers may order. So it's the whole range of things that an IHO might consider as relief in a case. Probably the biggest topic with regard to it is the idea of making placements, actual specific placements that could be ordered. And so that will be a major part of the operation. But I'm hoping also to talk about things like ordering compliance with procedural requirements, orders for evaluations, consent, as well as things like diplomas, modifying records, orders for future conduct in general, and even declaratory type relief. So to get right into that, the first topic or subtopic within that is ordering compliance with procedural requirements. And the main thing that I was trying to highlight here is that probably all of us have been exposed from some time ago, from the last time the rules were, the regulations were revised in 06, the requirement that hearing officers in general should decide cases on the basis of whether there's been a denial of free appropriate public education, and that there are some limits as to when and when not that will happen. But the regulation is quite clear that even if there is no finding of denial of free appropriate public education, that the hearing officer may order compliance with procedural requirements in the future. So in other words, if there are violations of procedural requirements, but they don't rise to the level of having denied the kid FAPE, haven't denied the parent's ability to participate in the process such that some remedy for that is required, it still may be permissible for the hearing officer to order compliance with procedural requirements in the future. Now, I think there is a little bit of a nice question that can be made as to just what it is you need to have as, I guess what I would call as a predicate to that. Does it mean simply that you as a hearing officer are worried that there will be some failure to comply with procedural requirements in the future? Or instead, is it a little more that there's been some actual violation of the procedural requirements, albeit not enough to amount to a denial of FAPE? The one case that I was able to locate that seemed to address the issue as closely as I could find, although probably not in a fully satisfactory way, talks about the idea that there's been a denial in this case of procedural requirements, but not a denial of FAPE. The hearing officer should have ordered the compliance with the requirements in the future. That's what the parent had asked for in relief. And that in and of itself is enough, but it seems almost negatively to imply that at least you have to have had some failure to comply with the requirements in the past. And so it would seem to me anyway that the necessary predicate for that kind of an order would at least be some failure to comply in the past. That's that Dawn G. against Maybank case. It is admittedly an out-of-area case and about as far from area as it could be given that it's from Texas. But I think its analysis is persuasive in that regard.
Mark, this is Lynn.
Yes.
Can I comment?
Yes, Lynn?
I think hearing officers are most frequently tempted to order compliance in situations where there has been no actual violation, when they perceive that a school district is so screwed up with regard to a case that no matter what he or she orders, they're not going to get it right. They kind of go overboard. And even though the district may have only violated procedural part A or B of something, they'll go on and say, you got to follow A and B. And by the way, I got to follow C, D, and E next year too. And I think that is obviously, I agree with what you said, and I think, but that's the temptation that we too often are provided, and we have to make sure we don't take the bait.
You know, one of the things, though, that we always talk about in remedies in a law school course is the idea that usually if it's permissible for for a judge making a court order to go a little bit, at least, beyond what the actual violation is. You know, if you've got a protective order, for example, you can go ahead and order the stalker to stay within a certain distance, even though it otherwise wouldn't be a violation of the law to be within 30 feet of the potential victim. But it does require that there have been something in the past that does support what it is the judge, or in this case, the IHO, is going to order.
You know, Mark, the one other observation, and that is that the statute seems to be a lot more expansive in its language than the corresponding regulation, because if you go back to the regulation and speaking to this section that speaks to an IHO ordering an agency to comply with procedural requirements, they limit it to the 300-502 to like 508, whatever it is. Don't quote me on that. So it's noteworthy that the statute itself has a much more expansive view of what the hearing officer can do with respect to requiring an agency to comply with procedural requirements. I also have a comment from or a question from a hearing officer. If an IHO finds that there was a procedural violation that did not result in a denial of FAPE, of what use is an IHO order that the district comply in the future with a requirement that even in the absence of an order, the district would be subject to? How would that be enforced?
Well, you know, one interesting thing I think on that is that it might still be incumbent then on the state education department to make sure that that is enforced. But if you did go ahead all the way to the end of the outline, where there's comments with regard to declarations, it does seem that courts are willing to accept the idea that there's been a declaration of something and view that as a form of administrative res judicata. So it might actually be determinative in future proceedings, if nothing else. So I think that would be a way in which it would actually have an impact.
Agreed.
If we're moving on, the next thing that I'd like to talk about for a bit is the idea of orders for evaluations. And here we've got something that both the New York regs and the federal regs are in agreement on, that ordering an evaluation may be something that a hearing officer may do. I've got one SRO decision that I've listed in this that's I think fairly well written and well thought out and persuasive ruling that supports evaluations in some areas, rejects evaluations in others, but serves as an example of where that kind of relief is found to be proper. The SRO went on and decided various other issues in the case, and we'll actually talk a little bit about some of the rest of what the SRO did a little bit later on. But I think if you're looking for authority at the SRO level for that sort of an order, this ruling does stand for that. I've also got an out-of-district case, actually Eastern District of Arkansas, but it's fairly recent, that once again does provide for the idea that an IHO who made an order for an evaluation, that order has to be taken seriously and enforced. And in fact, the court even orders a preliminary injunction to require that it be forced or that it be put into place. And there's a kind of similar case from Georgia that I was able to locate as well. One of the interesting problems in researching this topic is that finding cases that are organized according to relief is a bit of a challenge. I was able to use the LRP material and the LRP indexes, I think, fairly effectively, but sometimes I was looking a little hard to try to find cases that actually did deal specifically with a given kind of relief. The one thing that I've maybe entered into half a dozen conversations with hearing officers, and seems to really be a recurring problem with regard to evaluations, is where the parent prevails in a case in showing that a kid has been denied FAPE. The parent, though, has not, or at least not principally, laid out much in the way of money for tuition reimbursement, typically because they can't afford it, and is seeking compensatory education, but the parent's lawyer or the unrepresented parent doesn't have evidence put in as to just what that compensatory education ought to constitute, how long it ought to go on, if you're not talking about a specific day per day type evaluation, or even if you are, what the content of the education ought to be. And I do know some hearing officers who say, well, you know, it's the parent's burden, and if they don't put it in, then the proper thing to do is to find that there's been a violation, but not to order the compensatory relief for lack of a support for it. But I did, over the last couple of years, start looking for authority on this precise question. What I was able to come up with really are a couple of cases from the District of Columbia. So again, not specifically New York, but both of them are in agreement. And what they contend is that this is a particularly proper instance in which the hearing officer should be ordering an evaluation. The idea of the evaluation in support of the compensatory education remedy. And that's both the Butler case that I've got in the outline on page 3, and there's a case pretty similar to it, a case called Lopez-Young. And I suspect there are other cases that are at least from DC that do roughly the same thing. There are obviously some problems with that. It almost inevitably will mean that the case is going to drag on past the deadlines for making a decision. And so it would seem to me that if a hearing officer is contemplating that it would certainly behoove the party who would benefit from the evaluation and from the relief to request an extension of time and cite as good cause the need for the evaluation. And obviously that person would be hard pressed to complain about the fact that the hearing officer decision will be delayed when, after all, that party failed to put in evidence on the topic. But I did want to at least throw that out and suggest that there is some authority for the idea that this could be an instance where an order for evaluation would appear to be proper. Couple of other things that may be of interest. I've got some materials that I put in the outline that may be of interest about the idea that if the hearing officer does order the evaluation, that then would need to be at public expense. I did notice that there's a typo on the bottom paragraph of page 3 of the outline. The second line where it says conduction, I think, was where autocorrect struck again, and it should, of course, be condition rather than conduction. But what I do is list at least one case that talks about the idea of the evaluation at public expense. The general idea of the independent evaluation as an underlying right is maybe a little different from that. So you've got, on the one hand, the requirement that if the hearing officer does order an evaluation, that's got to be a public expense. But also, the regulations do provide that a parent may request an evaluation at public expense if the parent is dissatisfied with the evaluation that the school district does, and that then is the obligation of the school district to demand a due process hearing to try to defend its evaluation and resist having to provide the independent evaluation at public expense. I did cite in the outline, and I think it's worth keeping in mind, that there was actually a challenge to that regulation saying that that exceeded what the Department of Education could do in taking the language in the statute about evaluations and transmuting it into a requirement for evaluations at public expense. As the people who are asking for the evaluation in that case said, actually what the Department of Ed did was seemingly quite well supported by the legislative history. And given the fact that there's a lot of deference to the Department of Education in writing rules, it's not surprising that the 11th Circuit upheld the authority. But I wanted to make sure that people had the authority available if they wanted to rely on it. The other question, though, that does arise in an instance where the parent demands the evaluation, where the school district resists and takes a due process hearing, is just what relief do you order at that point? It seems that there is authority, and I've cited this MZ against Bethlehem case as an example of that. Let's see if I can, oops. Yeah, so I should probably stop at this moment, and I'll talk about that in a moment, but Deustati, I think, wants to jump in and tell about the code.
I do. I'm multitasking here. I'm sending a bunch of emails and responding to some hearing officers, reading questions and all that. Code number 2 is on the screen. Code number 2 is on the screen. So please write code number 2 on the on your affirmation form or on a piece of paper, whatever it is. But make sure you get it, jot it down. I'm going to leave it up while I ask some questions
Okay, sure.
of Mark. So Mark, there are a bunch of things coming in here. Some of them are from the order section and the remedy section on that.
Sure.
What about orders to remedy substantive shortfalls that do not constitute a denial of FAPE?
You know, the regulation doesn't actually say what the ordering the evaluation type relief requires, you know, just what the predicate is. What I was suggesting is there has to be at least some violation, and I was thinking of procedural violation because it didn't, at least from my thinking, to make sense to order compliance with procedural requirements as a remedy for some substantive failing that does not rise to the level of a denial of FAPE. I suppose you could have a situation, I guess the classic one in New York, of the instance of a substantive violation that doesn't rise to an FAPE violation would probably be the failure to provide parent training when, in the hearing officer or the SRO's view, that is not of such great significance that it amounts to denial of FAPE. I guess there's nothing in the statute that forbids the compliance with procedural requirements as an order with respect to that, although I suppose it may be possible for the hearing officer to order compliance with that substantive requirement in the future, although I have to admit, I don't think I've ever seen that. So I that's almost a confession and avoidance rather than a direct answer.
I mean, there's also the situation where you will have like an initial case and you're ordering an evaluation as a result of failure to child find. There's no denial of FAPE at that point, right?
Oh, that's true.
Yeah, but clearly you can order that as a hearing officer. Let me move on because I have a bunch of people writing here.
Okay.
That's a hot topic, apparently.
Yeah.
And in ordering an independent evaluation, is an IHO bound by district's policy regarding independent evaluations, i.e. geographical distance, costs, etc.?
All that I've seen on that topic is the idea that the standards for the evaluation need to be the same as that which the district is bound to, which in the interpretations I've seen, it really relates to the qualification of the examiner rather than anything else. And usually it is the idea that the state will have various requirements as to what an evaluator, either used by a school district or by the state, what requirements that individual has to meet. I do know that there are some opinions that say that reimbursement for an evaluation that the parent has undertaken because they were dissatisfied with the districts and where they prevail on the merits of that may be diminished because the amount is in excess of what would have been needed. I don't know if I can cite you chapter and verse on that offhand, but I have a strong recollection that I've seen opinions of that type.
Let me just add, I believe a hearing officer, in order to be independent on his or her own as a hearing officer, at least ought to take a look at the district's criteria that they use, which, as Mark indicated, is an attempt to put the independent evaluator in the same position as the staff. But I think there's a lot of law under IDEA that says if there are cost limitations, qualification limitations, which usually the parent, but in this case the hearing officer, could justify on the record needed to be exceeded or violated under the unique circumstances in that case, then they could deviate from those conditions or those criteria that the local district had established. But I think it'd be smart to note those when they're ordering the independent evaluation, where it would be contrary to that local district's criteria.
Yeah, I would agree with that real strongly as well, and I think that is the key. You know, if the kid needs some really exotic evaluation and there really is support for that, obviously the costs might be greater than what the district might be used to paying or what the state might be used to seeing for a given kid's evaluation.
I'm going to move on with some of the questions here so that we cover as much as we can. Due process complaints often contain requests that the hearing officer direct certain IEs. In such a case, should the IHO address such claims on an interlocutory basis? And if the IHO finds that the district's evaluations or assessments, I think is the appropriate word, was inappropriate, and an IE at public expense is necessary to fashion a remedy in the event of a denial of FAPE, is it appropriate to delay the proceedings while the IEs are being conducted? Would such action be impermissibly expanding the issues that the hearing officer is called upon to decide?
Ooh. I don't know if I can give a particularly persuasive answer to that one. It is true, obviously, that hearing officers are limited by the complaint, but that's almost hypothesizing that there's kind of a conditional complaint being made, that the evaluation is being requested, and then if the evaluation provides X, then Y is the complaint I'm bringing. If it provides Z, then A is is what I'm requesting. Now, it could be that you've got lawyers who are so concerned about the limiting of the evidence and the issues to what's in the complaint that they're trying to be as comprehensive as they possibly can, much perhaps to the difficulty of trying to actually make the proceedings work. I don't, obviously there can be a lot of different views about either the wisdom or the permissibility of taking issues piecemeal. I can really see the attraction of trying to get the independent evaluation out first, simply because often experts do wind up agreeing. And so you can sometimes see a settlement on the horizon if you've got the evaluation in and it either backs up what the school district did or it's more persuasive than what the school district has come up with. Whether that would be in compliance with what the SRO expects or what the NYSED expects, though I'm not really sure. And if there are other, Lynn or Deostedi, if you had comments on that?
Not here.
Okay. I'm going to move on to the next one.
Okay.
Sorry, I'm focused on the questions and the other things, so my mind wanders a little bit, so I don't hear exactly what you just said, Mark, so I can't respond to
Well, I'm not sure it was terribly useful, actually. New York lawyers are, as far as I know, somewhat more familiar with interlocutory appeals, or I guess more, there are somewhat more interlocutory appeals allowed in New York practice than there are, for example, in Illinois practice. I know that much. So it may not be that surprising to permit some kind of an interlocutory proceeding in an IHO type context.
I believe New York regulations, and some of you will cite this better than I can, but New York regulations restrict what can be interlocutory appealed. And I'm trying to remember, and those out there who are practicing for now will do this, but at some point it was limited to stay put. I'm not sure if that has changed since then, but we could easily get the answer to that. But New York regulations do restrict what can be appealed in the. Yes, thank you, Wendy. Yes, stay put. So some hearing officer chimed in. My memory served me well. All right, two more, and then you can move on. Please comment. Please comment on the cost of independent evaluators. What is quote at public cost? What determines the amount to be paid to the evaluator?
Again, all that I can really say is that there is some authority saying that if it's outlandish, that you don't have to provide it. But and I think in support of what Lynn had said, that if there's enough evidence in the record that would take you outside what would normally be paid, then that's enough to justify it. But if it is something that's going to be more than what would normally be the cost of a given evaluation of that type, then it would really be wise for the hearing officer to take evidence as to why that higher cost is justified.
Okay.
A lot of school districts will have cost as one of their criteria.
Mm-hmm.
And then you'd have a basis to work from in terms of what might be the customary charge for that in the locale. But otherwise, I agree with Mark.
So the initial hearing officer who asked the question is making a valid clarification, which is limitations on the interlocutory appeals limited to stay put, as we just discussed, are different from interlocutory issues by the hearing officer. And I'm sure in the context of an IE, it raises a host of questions regarding timelines, et cetera. If you need that IE before you can decide the issues, what do you do under those circumstances? I often query the parties when I get these IEs, is this truly an IE? Because sometimes you get the request for an IE, yet the issues seem to suggest that they're able to present testimony and documentary evidence to prove the case without the IE. And I have found at times that some parties sometimes just throw it in there just as a extra. Let me see if I can get another IE. Not necessarily that they need it for purposes of the issues, deciding the issues in the due process complaint. All right, I'm going to let you move on because I don't want you to get bogged down. We'll pick up again on the next break.
Yeah, we might be able to group some later comments as well together and maybe answer them appropriately that way. So I'm going to move on from the code page onto the next. And what we've got here is the site for the independent evaluation of public expense reg, and that Phillips C case, which is the one in which the 11th Circuit said that it's permissible. The Board of Education of Ossining is an SRO decision that contrasts with the MZ case, which is a Pennsylvania one. The big issue here is you can certainly argue that if the district failed to evaluate properly, then the parent has an absolute right to the independent evaluation of public expense, and that's what MZ says. The SRO, though, in that Ossining case said the hearing officer should, or I guess in that instance, yeah, it wasn't so much that it should, but it did affirm the hearing officer's ruling that the district be permitted to do more evaluation so as to meet the deficiency that the parent had identified in the evaluation that was done by the district. Again, that appears to be contrary to what at least that one court, which was affirmed by the Third Circuit, had said. What's the next thing? And I don't want to belabor at this point too much, but it's well established that the and provided in the regulations that a hearing officer may be called upon through the proceedings in front of the hearing officer to respond to the school district's request that you override a failure or denial of consent to evaluation. And that's this 300.300A3I. This was a modification from earlier law that actually had permitted the override not just of the failure to consent, but also the failure to consent to actually deliver services or to provide services. That was taken out of the statute, but this provision allowing for overriding failure of consent for the evaluation was included in. So that's something, and actually in our state amounts to a rather significant fraction of the hearing officer decisions in the course of a given year. The kicker on it, though, and the thing that I think there's a little tendency perhaps to overlook if you're not looking at the regulation quite carefully, is that the regulation does not apply if the kid is being homeschooled or if the kid is in a private school at parental expense. So that kind of works as a exception to this ability to override the failure to consent. I've got a couple of cases where that provision essentially is just followed, and that's that Durkee and the Fitzgerald case, but I don't think otherwise they're all that remarkable. What's the next topic? Well, the next one, as I promised at the outset, is really probably the biggest of the topics, and that is the idea of prospective placement and how it all operates or fails to operate. And I really kind of subdivide this into a number of subtopics in trying to make it a little more comprehensible. First, just talking about prospective placement of kids in general, and typically that means prospective placement in a private program. There are also, however, some cases specifically about emergency placements. There are a number of cases, including principally those from New York, about whether the hearing officer does or does not have the power to require a kid to be placed in an unapproved placement, a placement not approved by the state educational agency. And then I thought I would also look for, and I did manage to locate, some cases where it appears that you would need to, or it would be appropriate to order the kid to be put into a non-approved placement. One possibility might be to bring the state agency in as a co-respondent in the due process proceedings so that the state agency could be ordered to approve a given placement as well as the school district ordered to make the placement. And there is some authority for that as well, and that would be the final subtopic about joining the SEA as a hearing respondent. But to turn to the general topic of prospective placements, in some ways this seems a little bit a corollary of the early cases about tuition reimbursement, where Burlington, for example, said if the parent puts the kid in a private school, you're entitled to reimbursement if it turns out then ultimately that the school district did not offer appropriate ed, and if the placement that the parent did or found did offer appropriate education. So it's not surprising then that the hearing officer would have the ability to order a placement, just as the parent would have the ability to undertake it on the parent's own. And in fact, there's a quote directly out of Burlington that more or less reasons from the idea that, well, if the hearing officer can do that, then the parent ought to get reimbursement. So sort of taking it as an a fortiori point that the hearing officer would have the ability to do that, although they talk about a court doing it rather than hearing officer. I did want to throw in, though, the idea that simply because the hearing officer has the power to do it doesn't mean that it's necessarily the best thing. And so that one student with a disability case, which is the one that fortunately, so many of the SRO decisions are captioned as student with a disability. So this is the one of February 18th of 2014. Says, yeah, it might be appropriate to order a placement here in a private school, but the fact is that there hasn't been consideration of whether that comports with least restrictive environment type principles. And so, in fact, that may not be the best solution in a given instance, but it might be. It's sort of leaving that possibility open. There are a couple of relatively recent, sort of 2016 cases from the, again, out of area, from the District Court of the District of Columbia, where it seems that at least waiting in the wings somewhere is the argument that, well, the hearing officer ordered placement in a private school. Admittedly, we, the District of Columbia schools, screwed up in this case and denied FAPE, but we think that it would have been a better solution to have ordered something else, ordered us to find a better placement in the public schools or to reconsider with regard to LRE and whether placements are available or are not. But interestingly, in both of these 2016 cases, the DC court said, yeah, but the real problem in both of them was simply what appeared to be either unexcused delay or simple neglect on the part of the DC schools. And so the judges said, look, the only placement that we see out there is a private one that the parent found, that the parent enrolled the kid in but can't pay for. And so we think, at least for the foreseeable future, the order has got to be to place the kid in that setting, because it's, as they say, the only placement in the record that appears able to meet the kid's needs. Not as though there couldn't be others, but they more or less throw the burden then back on the school district. If you've got something better than this, come forward with it. Otherwise, we are going to order this, and in fact, they do order that. So that's why I wanted to make sure that those were kind of in front of you to see whether you at least would consider them as possibly persuasive in an instance where that's basically what's going on. Although obviously the INRI student with a disability precedent would provide support for a different approach. Again, at least if you've got a district that's being diligent, but where there's simply an actual disagreement over what's appropriate for the kid. I do throw in as well a Pennsylvania case about prospective relief. Mostly what it does is emphasize the idea that, after all, prospective relief is an equitable remedy, and that you don't, again, want to order private placement without an adequate justification for it, that some denials of FAPE will not support a private placement, whereas others will. They actually found in that case that a private placement was required, but I thought it was a particularly thoughtful discussion of when it is that order ought to be entered as opposed to others. And I've got a few other cases that order placement in specific programs, although not all of them actually are private. So it might be worthwhile taking a look at those if you've got an instance where you think that form of relief would be appropriate. And then I do list on page 7 of the outline a number of cases in which the court or the hearing officer basically says, no, we really don't think in this instance that a given private placement that the parent wanted is justified on the basis of the record and what the kid needs. So that would include that Danielle, Parents of Danielle case out of Massachusetts. It would also include the Wilkes-Barre, Pennsylvania case that I've got there at the bottom of the section with regard to these kinds of placements. The Wilkes-Barre case also, I think, gives a little bit of caution that you don't want to, as the hearing officer, start making offers that are making orders that look conditional and that may depend upon things that may or may not arise. And that I'm not sure that that would always be the case, but I think in general, it's probably a good idea to restrict any order to those conditions that have actually been found to exist. And once you start getting into trying to control things downstream, there tend to be some greater difficulties with making sure the relief actually meets what the kids' needs are at any given time.
Well, Mark, let me just add. I think your comment there is well taken because obviously the idea scheme is year to year. And I think any reviewing court may very well, with that in mind, be rather critical of any hearing officer who goes beyond at least one school year forward for reasons that the kids' needs may change during that period of time, which is why we have annual IEPs.
Good point. Yeah. Yeah, so this is at least one opinion that supports that idea, but I think common sense might be there as well.
Hey, Mark, let me just jump in because I had a couple of comments and some
Sure.
and a couple of questions. But yes, it's, as all of you should be aware, any decision of the state review officer is not binding.
Right.
It's persuasive. To the extent that we can get the decision numbers from the state review officer, we will be mindful of that in the future and put that in the outline as well.
Oh, okay.
Yeah, you're probably looking it up on their special ed connections, and in order to get the numbers, you would have to cross-reference it to the Office of State Review's own website. They do use a numbering system, but so we'll be mindful of that in the future. One hearing officer does comment that the State Review Office's position as to the very limited circumstances in which the hearing officer can direct the district place a student in a private, non-state approved private placement, as well as the cases that the State Review Officer views as relevant to that issue, is described in detail in BOE of the Florida Union Free School District, which is appeal number 17-006. So again, 17-006, that's one hearing officer's opinion of where the state review officer talks about, quote, very limited circumstances. Does pendency automatically apply in such cases, assuming the hearing officer orders, the hearing officer's order is a final order? And I'm presuming that this came in the context of the hearing officer ordering placement in a non-approved program.
I think the answer to that is yes. Certainly and this is a little bit anticipating what it is we're going to be talking about momentarily, but I think that Sabatini case would support that idea, albeit indirectly. That being said, I've expressed personally a little bit of skepticism. True, the Department of Ed has made a definitive ruling on this, so it's not going to change. But in a way, I have a little bit of sympathy for the school district's positions that since the hearing officer is actually independent of the state, describing the hearing officer's decision as an agreement by the state that would then trigger the state put does have a certain logical disconnect to it. Nevertheless, that being the interpretation of the Department of Ed, that being a consistent interpretation of the Department of Ed, that's not something that anyone is going to change. And in many ways, it may just be a good thing, irrespective of whether it's particularly logically supported by the text of the statute. Maybe we'll mention a word or two about emergency placements if we're at that, and then go on to the topic that I think actually was the original inspiration I think that Lynn had for this topic of prospective relief in the first place, this idea of unapproved placements and how that plays out. So on emergency placements, I really just had a few cases that I wanted to make people have in their kind of arsenal or their quiver of potential authority that might be of interest on the topic of emergency placements. And one case, the District of Columbia one, it just seemed the facts were particularly poignant. You've got a kid who's actively suicidal. It appears that the kid needs a placement that's quite restrictive. The District of Columbia is not willing to order it because they want to wait sounds almost as though they want something else to fail before they're willing to try that. And the court says, no, with a kid in this kind of crisis, you can't do that. Now, obviously, there are some questions that could be raised as to, is this educational? Is it not educational? All of those sorts of things. But the idea that when a kid is in crisis, that emergency placements may be required, I think is probably not particularly controversial. The couple of New Jersey cases, though, that I'd thrown in from the ALJs there, I thought were of interest because they show the ALJs using what is just a conventional preliminary injunction or temporary restraining order standing, or temporary restraining order standard in figuring out whether an emergency placement ought to be required or not. And that is, of course, a good, strong, well-supported framework that might be used to guide decisions, and probably is a sensible thing to do, at least in my opinion. Let's move on then to this topic. Oh, wait, we can't do that because first there's yet another affirmation code.
Yes, there's a code on your screen. Code number 3 is on your screen. Just for clarification, though, I think it's clear, but someone asked, so I want to make sure that we are being crystal clear. The course code is code number 1. The course code is what the New York State CLE board uses, so I try to keep to the language that they have, but there is a course code section on your affirmation form. So long as you give me 5 codes at the end of the program, you're all set. So code number 3 is on your screen. While we are doing leaving that up for just a minute or so, I just want to make sure. Good point. Hearing officer there points out that they're going back to the pendency issue that came up in terms of if the hearing officer orders a placement, is it the dependent placement of the child? The hearing officer points out that there is an OSEP letter that says that ordered placements become the pendant placement for the student. And that is, by the way, that information you have, it's in the outline I gave to you, I think 2 years ago. It's in the outline on OSEP memos, so that you can find the citation to that there. Let me just.
I think it's also in the book. If anybody goes to the library and picks that up, I'm pretty sure I've got a cite to it.
What book?
The book that I did on special ed law. I don't want to use this to plug the book, for heaven's sake, but
yeah,
there's authority on it.
They don't have access to your book.
Yeah.
That unless it's on, but it's on special ed connections. You can look it up.
Yeah, that's true.
But if we are to cite to these authorities, leaving a 1 second, that's not the one. I understand that the district needs a decision by a hearing officer for reimbursement of placement in a non-approved school. I'm not sure if that's a question, a statement, or.
Well, let's hold off on that one because I think that the writer might want to add to it once we get into the topic that I'm about to get into. Okay. Okay. Are we ready to move on? Do you think that people have a chance to write on? Okay.
Yep.
So unapproved placements. What about unapproved placements? There is Second Circuit authority essentially saying that neither a hearing officer nor, it seems, anybody else may order a prospective placement of a kid in a school that is not approved by the state Department of Education, and that's that Antkowiak case from way back in 1988. As observers have pointed out, that's a good 5 years before the Supreme Court decided in Florence County against Carter that a parent may be given reimbursement for a placement of a kid in an unapproved school. The reasoning that the court used in Carter, though, could be taken either quite broadly or quite narrowly. On the one hand, you could view it as saying, well, the kid's entitled to an appropriate placement, whether the state approves the placement or not doesn't say anything necessarily about whether its educational program is appropriate. It simply goes to whether the placement has jumped through the necessary hoops, whether it's got the various financial things that the state might have required, whether somebody has asked for it to become approved, because often states enter or deny approvals really on a totally ad hoc basis rather than on a more systemic one. On the other hand, you could read the case quite narrowly as well, because the court says, well, what we're saying is that the requirements that might be applicable to a school district or a state don't necessarily apply to a parent. And in fact, one of the more persuasive aspects, I think, of Florence County is, or Carter, is simply that the parent doesn't have any control over the state's granting or not granting approved status. And the parent's actually in a fairly bad situation in any instance to try to figure out what the best place is to place their kid if they've got a bona fide and supportable disagreement with the school district as to where the kid ought to be. There's authority that goes in different directions on the topic of whether a hearing officer or a court or a school district, for that matter, may place a kid in a placement that is not approved. And I've tried to basically locate that which there is that is pertaining to New York. And, you know, the point's well taken that SRO decisions are not viewed as being binding authority by any means. Frankly, you know, neither really necessarily would be a district court decision because you can find district court decisions that go in different directions. And here there hasn't been a definitive ruling, as I think we'll be able to point out. To my mind, probably the single strongest authority for the idea that the hearing officer may order a placement of a kid in an unapproved placement, an unapproved school or other setting, is the Sabatini case going back to 1999. It's a preliminary injunction case. The hearing officer, the IHO, had required that the kid be placed in an unapproved school. It's one that the parent had picked out because the school district had not been able to locate an approved school that would meet the kid's needs. The school district appeared to agree that the placements that it had come up with were not appropriate and that the placement that the parent came up with was appropriate, but the district was really in a way stymied by the Department of Education's failure to approve, and they, or at least felt they were, and so they didn't do the placement, and the parent was able to get the kid signed up or get the kid enrolled, but again, wouldn't necessarily have been able to pay for it. The hearing officer said, go ahead and the placement ought to be there, and the Western District of New York, the district judge, said preliminary injunction granted. So that would seem to be a pretty strong support. What they relied on, what the district court there relied on, really was Florence County against Carter, and said that had rendered Antkowiak no longer operative, at least in the context of this situation. What they pointed out was that a reimbursement case that followed Antkowiak, a case called Tucker, was one of the ones that Carter had actually affirmatively disapproved. And the district court felt that was closely enough allied to Antkowiak that it shouldn't be, that Antkowiak should not be viewed as being controlling on this issue. Now, the case did not go up to the Second Circuit, so the Second Circuit did not have occasion ever, and as far as I can tell, has not since, to reconsider whether Antkowiak is or is not still good law. So at this point, what we've got is Antkowiak out there, and we've got Sabatini as, I think, the strongest decision so far, saying go ahead and place the kid in an unapproved setting. And in fact, we're ordering that in the capacity of the district court to do that. And in fact, what they said, really effectively was, yeah, the state does have an interest in trying to manage private schools, and it has an interest in making sure that private schools are doing what they should do, that they're complying with all of the various rules that they ought to comply with. And the district court didn't want to say that that was trivial or unimportant, but they did say that, what's the quote? In this circumstance, the state's interest in maintaining its approval process must yield to the child's and society's strong interest in making a FAPE available when mandated by IDEA. So it does support that idea quite strongly. Interestingly, that was a placement of a kid in what purported to be a post-secondary setting that in fact did offer secondary school type education. And I could see how the state might easily have thought, well, wait, this doesn't make any sense at all to approve this because it's a post-secondary institution. I'm not sure that whether there was any effort on the part of the school to actually alert the state to the fact that it really was a post-secondary institution, but offering secondary education, which might have made the state look at it somewhat differently. The other case that is often looked to, I think, is in many ways kind of looking at things very much the same way that Sabatini does, but I think you'd probably have to describe what it says as dicta. And this is the Connors against Mills case. Not much longer ago than that. The 1998, as opposed, actually it's somewhat not as new as the Sabatini, which is 99. So 1998 in the Northern District of New York. Here, there was a settlement agreement actually where the kid was going to be placed in a Montessori school, but the Montessori school was unapproved, but the settlement provided for reimbursement, so it didn't appear that there was any problem with that under the Carter line, because under Carter you can reimburse even if you can't prospectively place, or even if there's an open issue as to whether you can prospectively place. So the settlement agreement seems to go forward with the reimbursement. The question then is, well, what about going on for the next year? What happens at the end of the school year? Subsequent due process hearing calls for yet another school year's worth of reimbursement, but then there is a dispute over what the stay put placement is. The district ultimately agrees to pay tuition up until an IHO decision on the now, I don't know whether it's the second or the third or the whatever, hearing that the parent has requested. As you might have guessed from the fact that Mills is captioned as a defendant, Mills, I believe, was the state commissioner of education. The parent in this instance joined the State Department of Ed as a defendant, but interestingly, the court doesn't seem to place a lot of emphasis on that, and instead emphasizes the same points that really are made by Sabatini later on, that you can't necessarily say that the placement is inappropriate simply by the fact that it doesn't have the approval. As they say, the statutory text is not quite as transparent as what the opponents of the placement seemed to be saying. They thought that the text was actually much more preoccupied with the quality of the placement and whether it met the kid's needs than it is anything else. And the court, I think, makes kind of the common sense point that, well, the problem is if you haven't been able to locate a placement that is approved that meets the kid's needs, and there is one that is unapproved that does meet the kid's needs, then if the parent doesn't have the ability to pay, you really are denying what the court thought of as the more important part of FAPE, that is actually an appropriate education as opposed to one that met the definitional standards of being in conformance with the standards of the state educational agency. And there's a block quote that I've got on page 11 of the outline that tries to get that point across. The reason, though, that I would view this still as possibly being in the dicta category rather than what I would think of as direct authority, is that the court really did rely on this idea of this would prevent a parent who cannot pay from getting appropriate ed for their kid. They said that in this instance, however, the parent had not put forward any evidence suggesting that the parent couldn't pay. And in fact, given the reality that for the previous year or so, the parent had accumulated the bills and then had gotten reimbursement, it seemed almost to imply that the parent could, in fact, pay and then sue for reimbursement. So the pressing necessity that the court was relying on didn't seem to apply. And sure enough, the court then denies the parent's relief. Although here, and this sort of goes back to the topic of the question of what you can do in the way of making declarations or non-declarations. They said that, and this is just directly out of the outline that I've got on page 11, there's no allegation the parent can't pay tuition and seek reimbursement, so the parent loses, but the court says that unless circumstances change, the parent would be entitled to reimbursement from the school district simply upon demand without requiring a new IHO proceeding to call for it. Now, whether that really comports with IDEA, I'm not really sure, but the old line is that a district judge can do whatever a district judge feels a district judge can do. And it could be that the judge wasn't really thinking of how it is the process works with IDEA, but the district judge has a point that effectively there's now been a declaration that this is the program that meets the kids' needs. Nobody is disputing that. Reimbursement, therefore, under Carter would seem to be required. Therefore, the school district should pay up on demand. And I kind of suspect that the hearing officer might be bypassed in that setting, and that the district court, if the school district balked or demanded their own due process hearing or something like that, the hearing officer, or I shouldn't say the hearing officer, the district court then, I think, was making at least some implied threat that there might be perhaps an attorney's fees remedy or something else that might be used to make sure that the district does, in fact, pay up if the demand is made. So the upshot of it is, at least in dicta, this other case as well, the Connors against Mills case, seems to say that the hearing officer has the ability to do it if the parent can't afford to front the money and get reimbursed. So it's a somewhat more limited holding perhaps than Sabatini in that regard, but it does support at least an element of Sabatini, once again, that the parent's view of the kid's needs ultimately does wind up prevailing. What else is there? Well, there is an SRO decision and there's a district court decision affirming the SRO decision, but I think actually somewhat less adamant with regard to whether and when placement can be ordered in an unapproved school than the SRO decision is. So this is a decision from SRO Bates, quite recent, at least by conventional standards, 2014. And again, I apologize for not having the case number, but if you've got access to the LRP sources, I've got the site for that on page 11 as well. So kid has a variety of needs, probably the biggest of which are simply behavior difficulties. The hearing officer, the IHO, rules that the district did not provide FAPE, hadn't provided it for a couple of school years, finds that the student needs to be prospectively placed at a secure facility that uses an ABA type model, all of which appeared to have been supported by various evidence in the record. And it's also supposed to offer social skills training. Needless to say, it's not that easy to find a school that has that kind of capacity for a kid who's getting older, who's got serious behavior problems. And the IHO ordered the school district essentially to consider both approved and unapproved public schools, and ordered various other relief that appeared to be more in the nature of compensatory ed rather than an ongoing prospective placement, although the hearing officer, I think to be fair, didn't really divide it up in a particularly neat package for the SRO to kind of subdivide. The SRO says that, yeah, there's broad remedial authority on the part of IHOs, but also said that under the circumstances in this case, the order directing the school district's agency here to consider non-approved, non-public school placements was not proper, says that despite everything, and COEAC does remain the law until the Second Circuit does something about it, but then also points out a couple of interesting things. First says, oh, and by the way, you can, school district, ask the state to approve the non-approved placement on an interim basis, and that might solve all of your various problems. And then in what probably, again, would have to be considered dicta, but may or may not be persuasive, says, yeah, but notwithstanding everything that I've said, in certain limited circumstances, an award directing the district to prospectively place a student in an appropriate but unapproved school may be proper. And basically what the hearing officer does, the SRO does, is kind of echo everything that's in Connor v. Mills, saying that, look, what really is more important than anything else is getting the kid into an appropriate setting. Once again, though, they suggest that that would only be the case if, in fact, you really are up against a rock and a hard place, the way that had been hypothesized in Connor v. Mills. Once again, there's no showing here that a reimbursement type remedy wouldn't be adequate, and really there's no showing here that the only possible placement for the kid is in a setting that's unapproved. And so the school district's appeal of what the IHO had ordered winds up being sustained by the SRO. That then is what goes up to the ZH case that's also cited in the outline on page 12 at the bottom. So in ZH, the district court then gets the parent's appeal of the SRO decision. And interestingly, in some ways, it endorses what's in the SRO decision, both on the business that COEAC has not yet been overruled, and we, the district court, are bound by COEAC until it actually does get overruled. The district court seems to be strongly of the opinion that there hasn't been any implied overruling of COEAC by the Carter decision. That Carter, in the view of the district court, relied much more heavily on the idea that I'd mentioned a moment ago about these requirements don't apply to the parent, and so you can't hold up the parent's reimbursement for failure to comply with the state approval requirement. And again, if that's the way that the reading of Carter is made, then I think the district court's analysis has got some persuasive power to it. If, on the other hand, your view of Carter is different, that you think instead it's kind of placing the appropriate placement of the kid above anything else, which seemed to be the view, at least of the Sabatini court, and I think fairly stated probably of the Connor against Mills court, and possibly of the hearing officer in the decision below, then I think you'd feel differently about it and feel that there could be instances in which an unapproved placement could be ordered. The district court, for what it's worth, did say that they thought that the SRO should be deferred to here and had a number of positive things to say about the SRO, and did comment somewhat cryptically. The SRO decision observed that there may be, and they do a subquote, certain limited circumstances in which the school district could place a student in an unapproved school, specifically if the parent and school district agreed that the district cannot otherwise provide a student with an FAPE, but that those circumstances did not exist here. I don't know whether I'd even quite call that a reservation of the issue. Maybe it is, or maybe it's at least some hedging. But the way that it's phrased here, it isn't the judge saying, oh, and by the way, I agree. Instead, it's simply saying that that's what the SRO said. So I'm not sure that you would take ZH as any sort of a ringing endorsement for the idea that even in certain limited circumstances, that the hearing officer would have that power. I tried to find as much out of jurisdiction precedent as I could on this topic as well. And again, I felt that I was coming up somehow a little bit short, that it must have come up in some other instances, but this was essentially what I could come up with on it. So the cases that appear to be relevant that are from out of area, you've got Delaware County.
Mark?
Oh, yes, please.
Can I just jump in, because there are a number of comments, and you may be able to clarify this along the way, but a number of comments from hearing officers like to make the distinction between the hearing officer ordering the school district to place a child in a non-approved program versus the hearing officer ordering funding of an unapproved program that the parent has found and the child has been accepted. Distinction being that they're not ordering that the child be actually ordering the school district to contract directly with the private school. So I wanted to bring that that distinction that a number of hearing officers are wrestling with and asking, does that distinction exist? Also, there is a case out of the Southern District that one hearing officer suggests is the best case in favor of placement in a non-approved school other than Connors, and that is the Mr. and Mrs. A case out of the Southern District, which can be found at 769 F Sup 2nd 403. 769 F Sup 2nd 403, which is a 2011 case out of the Southern District. But if you might comment on that, the distinction.
Yeah, I would like to comment on the distinction, because in some ways it's a little hard to tell, but I think the Sabatini case looks to me more like the ordering the funding rather than ordering the placing. Whereas Connor v. Mills, it seemed like they were asking for the ordering the placing. We said that seemed to be my reading on it.
I mean, if you look at both Burlington and Carter, an argument can be made and the cases can be interpreted that the reason that the remedy came out to be reimbursement is because the number of years it took to litigate the case, right? You're reimbursing the parent, that you had parents who could lay out the money and they were being reimbursed. But can you look at Carter and Burlington to suggest that in an appropriate case where you do have a FAPE issue, that the hearing officer can just order prospective funding of that private school?
Yeah, no, and that may be something. I'm not sure that it would satisfy the ZH court, for example, that they might say that that's a distinction without a difference. But it might be more easy. It might be easier to support than perhaps an order to contract. It's a valid point. I don't know if any other of our Lynn or Deustati yourself, if you wanted to comment on this at this point as well, or what your thinking is on this.
No, I don't have any additional comments. Thanks.
Okay. So let's talk for a moment then. I will definitely look at the Mr. and Mrs. A case, and we may want to put out something that would give a little more detail on that. But I did want to comment a bit on the out-of-state authority that I was able to locate on it. So that includes that Delaware County case out of Pennsylvania. The issue there, once again, is prospective relief, and it appeared to be, it isn't exactly a placement, it's for services from people who were not certified by the state. So it may not be exactly the same thing. On the other hand, the court seemed to take a view that Antkowiak was, obviously wasn't binding on the Third Circuit, but they felt that Antkowiak was in fact now rendered obsolete by Carter, and that in this instance it was perfectly legitimate that there be an order that relief of this kind be permitted. And there are a few other kind of random cases. One, I guess the stay put issue is addressed in that In re Madison Board of Education case out of Connecticut. There are a couple of others. That Letter v. Tucker maybe is worth thinking about. So that's the one that has as its kind of its big quote: "It would be impermissible for a state education agency to have a policy or procedures to override a local placement decision in a school or program which has or has not been state approved for state funding purposes. The decision of the local placement team must be final without provisions for veto by the state or local education agency outside of due process or court action," which seems to imply that irrespective of whether the school district can be ordered to do it or not, the school district can in fact do it, place a kid in an unapproved setting, and that the state doesn't have the ability to override that. On the other hand, it doesn't really say anything about what the state might do in terms of, I don't know, responding to that. You know, would they then say that's fine, but you, the local school district, have to pay for it yourself? You're not getting any state reimbursement for that, or whatever else the state might be able to do. But it might be possible, I think, to read that letter in a way that that maybe supports the idea of the school district to place in an unapproved setting. Now, I did try to check, you know, a bunch of the, I think 75 or something, IDEA letters and other guidances got revoked, but I didn't see this one on the list. So heaven only knows. There might have been one that's similar to it that was on the list, but as far as I know, it's still valid guidance for what it's worth. Dobbins maybe is of somewhat less significance because it appears that there actually was a DC rule or statute that does allow hearing officers to place in unapproved placements under extreme circumstances. And if, you know, a state in its wisdom wanted to do that, that would be one thing, but obviously it's not the general way that things have happened. The Struble case is an instance where the court says, no, the hearing officer does not have the authority to order a kid to, or order a district to place a kid in an unapproved setting. And that's a case out of the Southern District of California, may or may not be persuasive to you. The idea is that the state binds the school districts to comply with the state rules, and the state's reg says you can place in a certified private school, and that means you can't place in a non-certified private school. So that's all that there is. You know, I guess you could probably mount a complaint against the state saying that they don't have an adequate continuum of placements or something like that. But again, that would appear to be more a claim against the state than it would necessarily be of the district itself. I've actually listed a couple of other cases where actually a couple of other cases where there are instances where either the administrative agency or the hearing officer says, no, it's not proper to place in an unapproved program, and that's that Winnicott Co-op School District out of New Hampshire. The couple of letters may or may not make any difference. There's a letter to McIntyre that you've got that's at the bottom of the discussion of this topic on page 14 of the outline. Sort of suggests that in the McIntyre letter that if the school district does wind up stymied by the state's failure to approve, that then would be an issue on which the state could take an appeal, or the school district could take an appeal against the state through the due process hearing process. But, basically litigation by school districts against states saying that the states haven't been forthcoming at providing the assistance under IDEA that is needed do not have a particularly strong track record, with most courts saying that the duties that the IDEA imposes are ones that run to the kid rather than running to a given school district. What else is there? Well, next thing,
there's a code.
Yeah, there's a code, yeah.
All right, code number 4 is on your screen, folks. Code number 4 is on your screen. Please jot it down. Code number 4 is on the screen. We will leave it there for 30 seconds to a minute. Let me see if I have anything for you. I think we've covered most of the questions I had on the distinction between placement and pay versus placement. So code number 4 is on your screen, folks. Please jot it down. All right, I'll let you move on.
Yep. Yeah, I think we can move on. So the next thing is, so I was trying to analyze this topic of the non-approved placement and thinking, if I were in, kind of putting on a litigator hat, how it is that I might try to address it. And I guess I was thinking that it really would make sense, I think, from the parent's perspective, that if there is really the only placement that's out there in sight that the parent thinks would work for the kid is this one that's unapproved, that the state seems to be adamant that they're not going to approve it on an ad hoc or an interim basis or something like that, that the logical response might very well be to try to join the state as a party in the due process hearing process. Now, there are various opinions out there from the district courts and probably even from the courts of appeals, essentially saying that no, the proper plaintiff in a due process proceeding is the parent and the proper defendant is the agency, the local educational agency, the school district. This, though, I think might arguably be an exception. Obviously there'd be an exception if the kid were directly served by the state, say as in a state school or something like that. But here's an instance where at least there's an arguable violation of the statute if the state fails to provide free appropriate public education by not permitting approval of what appears to be the only placement that would provide FAPE. Plus, I think the parent might very well be able to assert that there's a failure to provide a continuum of differential placements that could meet a kid's needs. So then the question really would be, would it be proper in that instance then for the parent to demand a hearing against both the school district and the state? And then what's an IHO is supposed to do in that situation? Do you try to keep the state in as a party when in fact what they're highly likely to do is to move to dismiss themselves out of the proceeding? What, if any, authority can you kind of rely on in trying to go forward with that? So there's a bit of authority there that maybe supports it. The Connors against Mills case, I think, probably does it, if at all, by implication. So the fact that, yeah, the court there did entertain a case in which Mills was a defendant. Obviously, the parent lost, but with the statement that the parent could win under other circumstances, and certainly not a statement that the state should have been dismissed from the proceeding by any means. In addition, there's that Straube against Florida Union case that I've cited at the bottom of 14. The parents in that case had a kid who was really quite a ways behind in school, but had now reached high school. The kid's placed in a private placement, kind of on a trial basis and makes what appears to be great strides while at the private placement. So needless to say, the parent then says, well, keep the kid in the private placement for heaven's sake, demands a due process hearing. District says that's okay, but once again, the school's not approved by the state ed department. The IHO seemed to say, yeah, the situation here is that there would appear to be denial of FAPE, but actually remands the case back to the district. Parents then go ahead and kind of sue everyone in sight. They go up and sue the State Department, the state officials, the school district, and the like. And the hearing officer here, you know, this is now before Carter, so does suggest that there is no ability to order placement in a non-approved school, but it does order the school district to develop a program that'll meet the kid's needs, and then, again, kind of conditionally says, oh, and if the kid actually, in response to that order, is found to need a residential placement, and there isn't one that's approved, then the state is hereby ordered to expand the alternative placements that are on its list of approved placements. So in a way, it's true it doesn't undermine ANCOIAC because it doesn't have any basis on which to do that in 1992, but it does suggest that there is ground on which you can order the state to do something, or in this case, the district court can order the state to place or to allow a given placement to be put on the approved list if that's required to be done. I also then did, although it may not again be quite as much in the way of binding or even persuasive authority as one might want, bring in a couple of more letters from OSEP. What they basically say is that, yeah, due process proceedings by parents may be filed against a state in proper circumstances, but they don't really tell you too much more than that. So it's really up to the hearing officer to determine whether the circumstances are proper circumstances or are not proper circumstances. I don't think they give you too much more guidance on that, although I do think Straube does actually give you some support were you to go ahead and to include the state as a defendant in a due process proceeding. There is in one of the cases, I think it's, I don't think it's actually Connors v. Mills. I think it's the Sabatini. They actually say that the state's not an indispensable party in a proceeding having to do with an unapproved placement. But obviously the fact that it's not indispensable doesn't mean that it can't be joined if that would be appropriate. What have we got after that? Well, I did want to mention, and I don't know how much to make of them or how to make of them or whether they're even particularly persuasive, but one of the things that really has struck me over the last year is there have now been a couple of decisions, one out of the Ninth Circuit and one out of the California courts, saying that it's proper to bring a non-state educational agency, this instance, California Health Agency, in as a due process IDEA hearing defendant. And that appears to be based on really peculiar California law where it seems almost as though the particular service that the kid needs, the provision of it, has been delegated to this state agency rather than being something that the school districts are charged with providing. And at least under those peculiar circumstances, both the federal and the state courts think that it's perfectly fine to allow the, this instance, the California Children's Services Program, a state agency, to be brought in as a defendant in an IHO type proceeding. Again, whether that would have any applicability outside of California, one might be entitled to doubt. That's really, I think, what I have to say about unapproved placements. Maybe it's too much, maybe it's too little, I'm not sure. I will, as I said, take another look at the Mr. and Mrs. A case and see if there's any guidance we can derive from that. Um, what else do we have in the way of additional kinds of relief, additional kinds of things that hearing officers might order as prospective relief? Well, I wanted to make sure that I mentioned the idea of either rescinding or granting diplomas or diploma credit, and a little bit about modifying records, and a little bit about kind of everything else. So those would be kind of our three remaining topics. With in terms of rescinding diplomas, this I think is an issue maybe whose time has passed a little bit, but in the era before it was as well established as it is now that compensatory education is a proper remedy. It seemed there were a fair number of cases where a school district had terminated a kid's services, and the parent responds by saying, no, the termination is not appropriate. You should not have graduated my kid. My kid instead should be entitled to services until age 22. I know that that's a problem because FAP is defined as elementary and secondary education. So therefore, as a remedy, rescind the diploma. In more recent years, it seems that there's less preoccupation with that, that in instances where there's been some denial of FAPE and the parent is requesting that there be compensatory education, the district courts seem much less preoccupied as to whether the kid has in fact graduated and whether the services can be deemed to be secondary or non-secondary. It's almost as though the fact that it's remedial does mean that we're no longer quite so worried about whether it fits neatly within the definition of FAPE. So it could be that the idea of requiring rescinding of diplomas is again not as big an issue as it once was. I did throw in one case that I knew of that's local around here that supports the idea that that may be proper relief, but whether again it would be likely to come up in your practice, I'm not at all sure. What I did though want to include was at least some ideas about whether credit towards graduation could be an appropriate item of relief. If the idea is that there is a broad discretion on the part of the hearing officer, broad discretion on the part of a reviewing court or an SRO to order relief, I guess there's no reason that credit couldn't be ordered to be imposed where it might have been withheld, say either for disciplinary reasons or for something else. It does seem, though, that the real issue is whether there is an adequate basis for the granting of the credit towards graduation. And so the one case that I found that seemed to be the one most closely on point, albeit quite a ways away from New York, is this Hills against Lamar case where the court essentially says, well, irrespective of whether or not somebody can order credit to be imposed, and in this instance grades changed, there isn't any basis for it here. That the parent had not showed that the remedy would be appropriate in an instance like this. They also seem to say that, I guess, even more directly that there is no showing in this instance that the remedy is one that's available under IDEA. I don't doubt that it's available. It just seems to me that you've got to have a pretty darn strong showing to get it. And so I found one California case that actually does seem to require the imposition of credit towards graduation, but there isn't much reasoning in the opinion, so it's a little hard to say that it's something that necessarily would carry much persuasive force. Again, I think you'd probably rely back simply on the idea of whether there is broad power to issue remedies or whether there's not. If there is, then I don't think that it would limit you from ordering that credit ought to be given, but you'd really have to have a strong basis on which to do that, and you'd want to make sure the record is fully in support of it if that were the case. Often, of course, as I mentioned, it's the parent seems to want to keep the kid at the secondary level rather than having the kid graduate. But there certainly are instances where particularly the kid would be interested in graduating. The parent might as well have be interested in having the kid be at getting the diploma. I did want to put in a little bit about modifying records, because records often are an area of preoccupation, certainly for parents and for parents' lawyers. And there is a somewhat cryptic part of the IDEA regs that talks about the idea of invoking a hearing to challenge information in the educational records that's not accurate or is misleading or that violates various privacy rights. But when you look at the regulations carefully, it seems that they are not talking about the conventional IHO hearing process, but instead are talking about a hearing under the Family Educational Rights and Privacy Act, under FERPA, and they in fact refer you back to the FERPA regs, which are the ones not at the 300 series, but rather at 34 CFR 99 point whatever series. So it might very well be appropriate under those circumstances if somehow a hearing request of that type is filed with the IHO, for the IHO to say, no, in fact, what you should be doing is demanding a hearing under FERPA, and the state or the local school district should be charged with how it is they're going to handle that. If they want to appoint someone to do that, obviously that would be within their ability to do it, but does not necessarily mean that there'd be the ability to have this authority on the part of the hearing officer. And in fact, there is a New York SRO decision, for what it's worth, saying that at least under this FERPA authority, the IHO doesn't have the authority to amend a student's grades. What about other orders for future conduct? Is there anything more that we can kind of squeeze out of that? Well, with regard to the other orders for future, let me just put on the screen for a moment. I'm interrupting myself, but I wanted to put the site to the regs that kick you over to the FERPA regs, and it's the INRI student with a disability, once again without a case number, but at 51 IDELR 261, which is the one that says the hearing officer doesn't have authority. Instead, a FERPA hearing officer ought to be doing it. What about other orders for future conduct? Most of the stuff that I've got here, and I don't want to belabor any of the various points that could be made here, are simply orders on the part of a hearing officer to require a district to hold IEP meetings by the Committee on Special Education and to formulate IEPs. So that would be the case in RG, where they created the original IEP without the presence of a gen ed teacher, where they should have had the gen ed teacher there, and the order that winds up being imposed is go ahead and have a new IEP developed with the proper personnel there. Interestingly, the court there said that the actual failure to have the person there was harmful error, that it was one that denied an FAP, but the remedy that is to do a new IEP meeting rather than anything else. As I mentioned, kind of continuing on through the outline, there are plenty of other instances where you've got kind of the order to rewrite an IEP, perhaps because although the evaluations identified an area of need, there are no goals that correspond to that area of need, or there wasn't an adequate evaluation in all of the areas of suspected disability. Sometimes in some of those cases, it appears that the evaluation has taken place in the interim. And so again, it appears that the court or the hearing officer in some instances says, look, I don't know what the best solution is, but I do know that you folks should make the decision with the proper personnel there, having done the proper evaluations and making sure that the IEP adequately lines up with what information the evaluations have come up with. And under those circumstances, the proper remedy could well be to send the thing back to the school district for determination as to what the IEP ought to contain, what services ought to be out there. And I've got various, there's a California SEA case that suggests that, as well as the one New York case, the RG case that I had at the beginning. There's an Indiana SEA case that basically does the same thing, but with regard to parental participation, which I'm not sure I'd seen in other cases, and I thought was worth flagging. The idea that the absence of the parent would be a justification for kind of a rerun at the CSE type level. I do want to stress that there at least are instances where it seems that the hearing officer or the court says that I've been requested various kinds of prospective relief, but no, that it's not proper, that it's not the sort of thing that is something that an IHO ought to be able to order. And what you're getting to here, I think, is essentially kind of the substance as to what amounts to a violation of FAPE and what really are sort of the remedial limits for denials of FAPE. But the one case that I did think was worth everybody knowing about, if you don't know about it already, is this RS against the Board of Education. And I really don't know how this is pronounced, but my guess would be Shenandoah Central School District, which came out just last summer from the Northern District of New York. What the parent basically said was, parent said the kid had been denied FAPE over a period of time. The parent identifies a school that would provide FAPE, but the school is in Massachusetts, and what they say is not only should the parent or should the placement in Massachusetts be approved, but also, or be required, but also that they, the parents, should be entitled to moving expenses so that they can move to Massachusetts to be near the kid while the kid is in the placement that they contend the kid needs. And the district court, I think, says, nice try, but really no. Yeah, there is authority for all sorts of different things. You can find authority for the proposition that parents ought to be entitled to reimbursement for visiting the kid in instances where that's therapeutically required. You can find cases that require payment for transportation of the kid back to the home if the kid is placed out of state under some circumstances. But no, there isn't any authority, and there's no reason to believe that there ought to be authority for actually relocating the entire family to try to pursue the one placement that appears to, according to the parents, be the one place where the kid could be served. I mean, in fact, the maybe you could say that the court hedges its bets at least a little bit by saying, look, you haven't shown that this is the only placement that can serve the kid. If you had, maybe we'll think of things differently, although I kind of doubt that the court would have thought of things differently even if that were the case. I know, Lynn, that you had you had noticed this case, and I think it brought it to my attention originally. I don't know if you had any comments on it.
No, not really.
Oh, okay. Nobody wants to throw in the correct pronunciation of Shenandoah either, I guess. So we'll kind of leave that be. What other limits could there be, or other things that we might want to think of as potential limits on prospective relief? Some of them I might actually be a little bit skeptical about. So there is a Pennsylvania decision out there from the days that when Pennsylvania still had a two-tier system, where the parent basically wants to combine a couple of programs for their I think it was a kindergarten kid, a very young kid. So it would essentially give the kid a bit of an extended school day by combining those two programs. And the appeals panel in Pennsylvania thought that was beyond the hearing officer's authority to do, because the way that the state law was written did not appear to allow for that kind of an extended program to be created. Um, Certainly you can argue that, irrespective of whatever the state rules might be on how many hours of a day you can have employees be required to be where the employees are or whatever, um, if in fact you need extended hours in order to provide appropriate education for the kid, some form of the extended hours has to be ordered. Now, practically speaking, I think anybody who's ever had a kindergartner knows there's a limited number of hours that any kindergartner could be expected to be doing anything really educational, and maybe there was a bit of an undertone of that to the case. It also was true in the appeals panel, I think, made it pretty clear that in their view, there really wasn't an adequate evidentiary predicate for the idea that the kid actually required this kind of extended services, that the appropriate ed for the kid couldn't be delivered in the course of an ordinary school day. For that reason, I think that it's actually that part of the opinion that is the more persuasive one. But it is true that school districts, I think, often do view themselves as being put in a very difficult position when they're asked for what the parent thinks is a quite sensible, albeit somewhat creative solution that might entail the kid being in the school for an extended period, or being taken from one part of the school district to another, or from a private to a public type setting, considering that, often they're bound by union agreements or they're bound by contractor agreements, and they just see it as being extremely difficult to do. But I think the point is that FAPE is FAPE, and that essentially is what has to prevail, irrespective of anything else. And so I think the real question here is whether there is a basis for the relief being requested, or whether there isn't. And so for that reason, I think probably the sort of the valedictory with regard to this part of the orders for future conduct discussion really is this one about the letter to Armstrong. So what that essentially does is say, look, there really isn't anything very specific in IDEA as to what the remedies under IDEA are. And there's nothing all that specific about appeals boards, about hearing officers, or anything else. They do kind of suggest that it would be a good thing for states to spell out a little more clearly what kind of remedies would be appropriate and when. Although I don't think I've seen much in the way of eagerness on the part of states to do that. But it certainly would be something that a state educational agency might want to give thought to, whether they might want to provide some guidance as to just what the appropriate remedy ought to be, or whether they think that, in fact, it does make more sense to let this just develop as kind of a common law gloss on the statute. That the hearing officers in individual cases are in a better position to figure out what remedies are appropriate. Trying to create guidelines is going to be futile. Let the hearing officers make decisions, let the parties make analogies to those cases where decisions have been made, and that'll be the way that the law develops here. Oops, wait a minute. Orders for future conduct. Whoops. I'm having some trouble with my mouse here, but I think I've got it now. So the final topic that I did want to address, and I know we're getting very close to the wire here, but was, so what about declaratory relief? Is that out there as a possible kind of a thing? And the question that came in at the beginning of the discussion this evening kind of cast some question as to whether a declaration really does constitute a useful form of relief, or whether it's just the hearing officer kind of talking to the wind. And I can imagine a hearing officer saying, yeah, I can declare all the heck I want to, but it isn't necessarily going to get anybody any good. What I think is important that I did, at least in my opinion, want to get across is that a declaration, if there is support for it in the record, may in fact be useful relief. It may or it may not be useful relief in other instances, but it may be useful relief. In general, at least in my opinion, it's a better idea to, if there is support for a declaration, to make the declaration as a declaration or to order something than it is, say, to make a recommendation, which you sometimes see hearing officers do, but then effectively appears to be unenforceable if the school district or the parent doesn't comply with the recommendation. There's a little bit of authority as to what declarations may or may not support, and I thought I would throw it out there for what it is worth. Cox v. Jenkins is actually a pretty well-known early IDEA. Actually, back then it wasn't even the IDEA, it was the EAHCA decision that says that, okay, there's been a declaration and a failure to, it wasn't actually a declaration, there were recommendations that were made by the hearing officer. The parent then said, well, since the recommendations haven't been followed, I can jump directly into court to try to enforce them as I might to the failure to comply with the hearing officer decision. And the Court of Appeals said, no, decision is one thing, recommendations are another. The recommendation is not enforceable. So I think that supports the idea that a hearing officer ought to be pretty cautious about merely making a recommendation unless they want to have the prospect that the recommendation may not be followed. On the other hand, declarations that have been given binding effect, so in this instance, not recommendations, but rather affirmative declarations, have sometimes happened. And this Board of Education of the City School District case from the SRO is an instance of that, where effectively a binding effect, kind of an administrative res judicata effect, was imposed. And that administrative res judicata idea, it turns out in this instance, was not something that the SRO wanted to latch onto, in particular because they didn't think that the case had adequately addressed that issue below. And so the one sort of statement standing out there in space was not adequate. Whereas on the other hand, the failure to provide a declaration, at least in the view of one district court case that I was able to locate, is actually something that could be appealable and could be a ground for reversal of a hearing officer decision. And that's that DC against Department of Education case that's at the very tail end of the outline. So that then, I think, is pretty much what we're covering here. And what's next, of course, is?
Code number 5 is on the screen. Code number 5 is on the screen. I will leave it up. I have one question that was on the declarations slide, and that question is, logistically, what is the best way to make the declaration within the body of the decision or as a standalone ruling?
Oh, that's a good question. I'm not sure what the answer to that is. I would suspect that it would be more likely to be enforced and given administrative res judicata effect if it's actually as an item of relief. Did Lynn or Diastati, did you want to weigh in on that?
I think it's going to have to be justified in terms of findings of fact, conclusions of law, and everything else. I think it ought to be a part of the decision.
I see.
Agreed.
By part of the decision, though, do you mean something that would be specifically spelled out in the relief section of the decision, or something that would merely be within the body of the decision opinion?
I think it ought to be spelled out, starting with it being an issue,
Uh-huh.
findings of fact and conclusions of law with regard to that issue, and then declared in the order of relief.
I see. Yeah. Okay.
All right, folks, the last code is up on your screen. Please write it down. A few things before we sign off. One is that our next webinar is scheduled for March 20th, 2018, March 20th, 2018. Obviously, I will send you a reminder to register, and I'll send you a registration email. 2, you can keep track of the dates of the webinars as well as the on-site dates in the fall, which I have already shared with you on our website, www.spedsolutions.com. At that, in the website, we also have a members page, which is you're the members, where we upload all of the materials from past trainings. All of them going back 6 years are uploaded there for your convenience, so you can find them. They're uploaded by dates, which was the easiest way to do it for us. Finally, from time to time, we will post new cases of interest, whether it's a Second Circuit, whether it's a New York State court decision, or decisions from around the country. And those are uploaded there, and you can have access to the write-ups on those. So again, spedsolutions.com. That is it. It is 8 o'clock. We like to finish promptly and on time. So thank you, folks. Please send me your affirmations. You can email them to me. You can mail them to me. The address is on the affirmation, or you can fax them to me. And that number is also provided on the affirmation. But in case, 203-557-6051, 203-557-6051. The number is also on my email, so just look up one of my emails and you'll have it. Thank you, Mark, for your time, and thank you, everyone, for your patience and your time this evening.